This meeting is being recorded.
Oh, are you? Yeah. I saw her. I do. That's what you do. This room is being like. I'm going to be one of the mock-ups. This is the export.
Where are you working?
And then what's that?
Which one do you have? Brown. These are the main programs.
Okay, so
This is the background.
Right, so,
Yeah.
you know, I
You'll have 15 minutes.
um,
what am I going to do with the other 10 minutes?
Okay.
That's not really contentious.
Wherever you want to start.
You can
So I'm not even.
use a microphone.
Sure.
Do you want to?
Yeah. But I have
5 minutes.
one other.
That's fine, you got 15. Okay, and you can kick off.
Hi. Hello, everyone. Oh, and I'll say hi to folks online and try not to stand with my back to you, but we've got a room full of people here at PwC in Washington, D.C. It's a real pleasure to see everyone here today. We have an exciting program on day 3 of Washington Arbitration Week. For those who don't know me yet, my name is Ian Laird. I'm a partner at Kroll and Mooring here in Washington, and I'm the co-chair of the conference along with my colleague, Dr. José Antonio Rivas of X Strategy. And just wanted to say a few opening remarks and then introduce our program and get things going. Washington Arbitration Week is now in its 5th edition, and we've had continuous growth and enthusiasm from the Washington arbitration community. As I've said in opening day 1 and 2, part of, I think, the unique model of Washington Arbitration Week, as say distinct from some of the other cities that do Washington Arbitration Weeks, is that we are looking to appeal to a broader global market. And part of the way we do that is we hold virtual sessions. And as you've noticed, our various sessions have been also available online. And we think that's a good thing, an objective which we like to promote to encourage international arbitration globally and encourage people to do their arbitration here in Washington, D.C., because we have a great cadre of practitioners and support folks like PwC who provide our expertise and make our arbitrations run. And we have the institutions, as you know. ICSID is here, and all the major arbitration institutions operate in Washington. So this is the place to be, and we're really glad to have this group today. We're doing something a little novel. Usually we do kind of the standard 1.5 hour panel discussions, and I think that's the main model for this week. Today, and this is with the urging and encouragement and hard work of PwC. We're doing a little something different. So a hands-on learning experience on a topic and area of experience that's absolutely critical to practitioners as well as our arbitrators, and certainly the interaction that you're going to see today with our experts is a key part of what we do. So this should be a great sessions. I think we're going to do 4 sessions. One will be in this room, but to get things going, I just wanted to introduce our kind of ringleader and the madman behind all this and making it work is Surshar Qureshi, who's here at PwC. Surshar is the Dispute Advisory Center of Excellence and EMA Forensic Services leader for PwC based in Prague, Czech Republic. And the Dispute Advisory Center of Excellence that Surshar coordinates is basically coordinates the efforts of partners and staff globally to ensure clients find the right expert for PwC's extensive network. So Surshar is someone you really want to know when you want to get things done, and PwC can certainly help you. But behind all that is over 30 years of expertise, which covers many aspects of accounting, financial matters, including loss of profits claims, construction claims, claims arising following acquisitions and sales of businesses and insurance claims, fraud prevention, etc. The list is a long one. Sir Shar is your man. And we're really pleased that you were willing to partner with us this year and bring this new element of Washington Arbitration Week. And I just want to thank you and PwC for hosting today. And I'll turn it over to Sir Shar to come in and get the sessions going.
Thank you very much. Okay, thank you, Ian, for those kind words. And yes, I'm the madman here, trying to pull this together. And I thank Washington Arbitration Week for really giving us the opportunity to do something a bit different. And I came last year for the first time to Washington for the Arbitration Week, and I really loved it. I enjoyed it. I loved the style of it, the way it was done. So I wanted to add to that educational piece, which is important. But then I'm throwing a little bit of a zinger by making it completely different to the normal panel session. So bear with us, and I'm sure this will be a great educational experience for everybody, and hopefully we'll enjoy that as well. So let me just jump ahead, because as with most arbitrations, time is tight. So we've got to make sure we keep to the schedule as much as possible. So that's a welcome night. So let me just jump to the case itself, just because I realized that everybody involved is aware of the case, but maybe people watching online or in the audience may have no idea. So I'll just give you the basic facts, and the rest you'll glean from the cross-examination and from the discussion around the panel. So basically, this is a case, bilateral investment treaty case, between LearnFast UK Limited and the Republic of Kaylia. The claimant, LearnFast UK Limited, they have counsel appointed. It's owned by Mr. John Peters, and LearnFast Kaylia is a wholly owned subsidiary of the claimant. Claimant's expert is Sam Smith. In every case, it'd be Sam Smith because it's his report, but obviously we'll have different people playing the part in the 4 different rooms. The respondent is the Republic of Kaylia. Yes, made up country, so don't look it up on the map. We have counsel appointed, and their expert is Chris Brown. So this is a classic investment treaty case, so nothing won't surprise anyone, but the claimant invested into the International Learning Center in Kaylia in 2000, the Caton project. In May 2001, Kaylia's Department of Education issued guidance guiding foreign investment in Kaylia, Circular 10, as you probably will remember, Circular 10, very famous circular, to the effect that this on the claimant was that it required them to convert the status of the international learning centers to a Kaylian school to operate as a functioning school similar to national schools. The claimant alleges that the Caton project and subsequently the network project was severely hampered by the respondent through the enactment of Circular 10 and other unexpected administrative measures put in place. As a result, the claimant alleges these issues destroyed the value of its investment in the Caton project. So that's a very high level setting the scene. And as I said, the rest of it you'll pick up as you go along for those of you who will be in this room. So here we have our arbitrators set up. So I'd like to thank all of them because they'll be the ones providing all the feedback in relation to the matter. So thank you very much to the arbitrators. Here we have our experts as well, who kindly stepped in to take on the roles. It's not just PwC experts there. We have Julie from NERA and Sensor from Compass Lexicon. So thank you for joining us as well. And here we have our legal counsels. Thank you for stepping up and stepping into the role of this case study, and hopefully you'll enjoy the experience as well. So with that said, as I said, time is tight. And I would ask the arbitrators to be keeping to the timetable as best you can, but I know that's something that arbitrators like to do. And here we have the rooms. So, there's the timetable. So we will have cross-examination of the claimant's expert, first of all, for 30 minutes. There'll be a chance for redirect. Then cross-examination of the respondent's expert, and then the chance for redirect. And then there'll be a short break to allow both teams to put together their closing arguments. And then there'll be the closing arguments, and the teams will then move back here, and we'll have a final debrief session for 15 minutes. So we need to be back here by 11:30. I've been told that this needs to finish by 11:45. So I'm really going to really do my best to make sure that we all finish on time. So that's great, because I know there's lots of very good events this today. So I need to make sure everyone goes to those events. So now, just for everyone online, we're going to have a little intermission while people move to their rooms, and there is the training rooms. And I believe we have people to help you move as well, for those of you who are not in this room. So with that, thank you.
Yeah.
Understand.
No pressure. I might.
As you can hear.
Nicholas.
Hi.
Nice
Nice
to
to
meet
meet
you.
I was up against Tiago.
Yeah, so, maybe we should probably get together. I can just,
But he wrote a report saying credibility of forecast. Any room you want. Yes.
we get to stay here.
Morning. Take a picture of it. Sure, we'll just talk about for 10 minutes. It doesn't take long to.
Hello. Hi. Thank you for coming.
I made it.
Yes, thank you. So let's just take a picture of it. Maybe the best thing.
Hi, Carol.
Hey,
Good to see you.
how are you? I'm going to your room.
Oh, great. So Covington, group 209-745.
Yes, you're with Jean.
Oh, thank you. That's very convenient.
I'm sick. Sure.
Oh, thank you. Thank you. Very thoughtful.
All the reports and the appendices.
Great.
Kennedy. Nice to meet you.
No, I'm sick. That's not your fault.
As you can hear me speak. Are you sick?
Good news is though, it's not COVID.
Oh, awesome.
I knew that would happen.
Yeah, we just. Thank you.
Go make our country proud. Or you're staying here? Just trying to. Yeah. Talking to some UK guys yesterday. Exactly. Not, I would argue not civil lawyers. Because, they've got more of a monkey voice sort of style. Monkey voice kind of strong. Actually got that from, that was a moot court I took. I did like, about 1993 maybe. And I was shocked by the Quebec participants. It was an administrative law move. They were just like jumping around and screaming as they won. Like it worked. We have, there's been a couple people.
I'm so sorry. Good to see you.
And his style is just so bombastic. Yeah. What's your point? Is there a jury here, something? Sometimes it's like respondent states, including the US, are like that. Although not always. It depends on who was in charge of the US unit at the time. Do you do jury?
Yeah.
Yeah, it's just for the level of demonstrators.
Lowest common denominator.
I'm gonna be able to save time because I don't think I need 10 minutes to instruct me. Yeah. Is that what it is? You have anything in front of you? Can I save you? Okay.
Reports unmarked.
Oh, I know what I'm gonna do. Uh-oh. I'm not gonna tell him that.
Yeah, no, I'm not logged in.
Say,
So I was just opening.
just executed and say, I am an expert. I promise to be good. You ready to come up with something like that?
You just went to the restroom.
We lose.
This was a real hearing. We would all have gone to bed at 2 a.m.
we'd be drinking our coffee and just barely get it together.
I went to bed at 12, 1, 2, 3, 4, 5, 6, and 7. And I actually consider that a good sleep because I have an 8-year-old with anxiety and autism and ADHD who usually sleeps in her bed. So this was actually better.
God, imagine what you'd do if you had 8 hours of uninterrupted sleep.
So taking a pill last night, that would have helped. That's why I thought I was dying, all the stuff. We're all dying.
You ready for this?
Grim.
Pretty active.
Wasn't the other day. I was kind of more active than the other two.
I'd say in the course of giving expert evidence, 4 or 5 interjections by the panel, typically points of clarification, or they don't like how the questioning's going.
I waited to the end. Generally prefer to wait to the end. And as a general rule, unless the other side has an objection, then, it's their responsibility to do something about that. Unless it's really, bad, then you just have to say something.
Yeah, if you get into stalemate over some line of questioning, that's your.
Yeah, especially when it's going. Mr. Such and such, could you please move on? Wait, I actually know your fake names. There you are. Dipfield, that's a nice name, Dipfield. You both sound kind of British. Hughes and Associates. Slater, solicitors.
There is, I assume we're live here, but there is a similar case to this in real life.
It might be live, but I'm not on. Can we begin? I guess we can begin. Can't we?
Do you know the case?
Yeah. Yeah, I actually also thought an Ambassador Bridge case at first, but they went slightly a different way. Also, actually, there's something that reminds me of, like, there's a case from the Court of International Arbitration. Chin, which had something of it. We have a director of this production. Could someone tell me when I should go? Okay. So first, let's see if anyone can hear me. We don't know. Good, okay. So I'm going to recommence the hearing. Good morning, counsel. Mr. Smith. Where are you going, Mr. Smith? Get back in your chair. Almost wanted to do take 2. Good morning, Mr. Smith. So we're moving on now to damages valuation. And I think we're going to hear first from Mr. Smith, and then we'll hear for respondent. Okay, so claimant, respondent, there you are. Please begin.
Good morning, Mr. Smith. My name is
Good morning,
Alexandra.
Alexandra. Good morning.
Respondent, so this is Wardavari.
Mortivari.
Good morning. So let's turn to your CV. Do you have that in front of you?
I believe I do. Having trouble finding it, but I could probably do it from memory if you want to
Okay.
go.
So based off your CV, you have not received any formal training in foreign investment, specifically in the Republic of Kaylia.
I'm not sure what form of training that would be, but yes, you're correct.
And you have not received any formal training, which could include education, classes, professional experiences in educational investments in the Republic of Kaylia?
No, I've had a number of, in the Republic of Kaylia specifically, you're correct. But I do have a background and experience in educational services and institutions on a number of assignments.
In the Republic of Kaylia?
No, not specifically in the Republic of Kaylia.
Have you ever reviewed any financial statements for companies or entities in the Republic of Kaylia, based out of the Republic of Kaylia?
Only in this instance.
Okay. You also state that you specialize in financial valuation and audits. Can you confirm how many times you have provided expert testimony in cases specifically related to international learning centers or educational investments?
Prior to this instance, once.
So we'll turn to your report now.
Just before we do, could you please tell me how much experience you have generally with regard to valuation, where it has come to a hearing and you've acted as the witness at that hearing?
Approximately 70 times in court or tribunals, and I've been doing it exclusively for nearly 30 years.
Okay, thank you. Go on.
In drafting your report, claimants provided you with documents for your review,
They did.
and you reviewed those documents,
I did.
and those documents formed the basis of your opinion.
In part, the documents, among other things. Yes.
You write in your report that claimant invested approximately 1.2 million in the Caton City project, right?
That is correct. Yes.
Just generally, what calculation did you use to form the basis of this number?
It's a combination of both debt and equity investment made from the parent company. Approximately 400,000 that was invested in the firm in the form of equity, and the balance as short-term loans from the UK entity.
And your review was based, at least in part, on the 2005 audit financial statements of Learn Fast Kaylia.
In part, of course, there are some qualifications on those statements, so I had to rely on the UK statements, which were unqualified and reflected the same loans.
And based on your report, you were unable to review any of the underlying financial records and books?
Correct. Those are in the possession of the respondents, and we were denied access.
And you were similarly unable to review any documents from the Kaylian Department of Finance?
Again, we were refused access to those documents.
Did you review any of the underlying documents used by the auditors to prepare the 2005 audit financial statements?
With respect to the Kaylian financial statements, no, we were refused access to those.
Did you review any invoices reflecting the alleged expenditure?
I did not.
Did you review any receipts reflecting the alleged expenditure?
I did not.
Did you review any documents evidencing any monies provided by the claimant and spent specifically on the Caton City project?
I mean, aside from the audited financial statements, which would, as a matter of accounting principles and standards, need to see those sorts of those documents that support, I didn't feel there was a need to perform an audit. My job is not an audit. I can rely on audited financial statements to substantiate those expenses.
So other than the audited financial statements, did you review any other documents evidencing the monies provided by the claimant spent on the Caton City project?
No, I consider unqualified audited financial statements as sufficient evidence of the money spent.
Is that unqualified?
Yeah, in the case of the UK financial statements, they were unqualified.
Okay. Did you review any documents evidencing any monies provided by the claimant to be spent on the Caton City project that was then also wasted?
I'm sorry, could you clarify that?
Did you review any documents evidencing any monies that were wasted on the Caton City project?
Sorry, by wasted, could you help me understand what you
Meaning
mean?
there was no return on the money that was spent.
Well, I think in effect, that would be all the capital invested.
All of it?
It would seem so, yeah.
Can you turn to, or do you have page 1 of your appendices?
I likely do. What does page 1 look like? If you could just help me.
It says. Chart, let's see, I'll redo it.
Look like
It is
this.
the extracts from the, I have extracts from the audited financial statements of Laird Kaylia. There's no page numbers.
Yes,
It
that's,
is-
yeah, that's exactly right. It's the same.
And do you see the, it's, I would say it's the middle of the paragraph where it, with the sentence starting with however?
Yes, I do.
Okay. Do you need a minute to read that?
I'm familiar with it. Go ahead.
So based on this statement, would you agree that the auditors qualified their report, given their inability to account for the $500,000 for the qualification?
Again, I will agree with your point, but I think it requires expansion. There was a qualification on these funds spent within the Kaylian financial statements. And as you see, as you read on, the qualification relates to the fact that the auditors themselves could not receive the underlying documents which are in possession of the respondent. The offsetting entry in the UK financial statements has no such qualification in it, which I take as evidence as if the UK auditors are satisfied that such a liability exists and is unqualified, I take that as sufficient evidence, notwithstanding the qualification of the Kaylian financial statements.
As sufficient evidence for.
Right. There's really two sides to the transaction, right? It was someone who's extended a loan and someone who's received a loan. If the financial statements of the party who has received a loan are qualified, that's a concern. However, if the financial statements of the party who have made the loan are unqualified, the auditors are obviously satisfied that such a loan exists and that amount is accurate.
Read that the actual capital invested could have been lower than the estimate given the partially qualified audit and missing documentation?
No,
No.
I see no reason to believe that.
Did you review, for example, any bank statements confirming transfers to Laird Kaylia for the Cane City project?
Again, those documents would have been in possession of the respondents. We refused access.
Did you review any loan registrations with the Bank of Kaylia for the Cane City project?
Same answer. Yeah.
Turning back to your report, I have paragraph 38, which I believe is page 20.
I apologize for the poor numbering in my report.
Sorry, page 12.
With you.
So according to your report, you rely on Mr. Peters' technical and economic feasibility study.
I do.
And just by way of background, who is Mr. Peters?
Mr. Peters is the claimant in this matter,
Okay.
the owner of Learn Fast.
And Mr. Peters is a citizen of the UK?
He is.
Okay. And this study was conducted in 2000?
Yes, that's right. May 20, 2000.
Prior to this project, do you know if Mr. Peters had ever invested in the Republic of Kaylia?
He had not invested in Kaylia specifically.
Do you know if he had any prior experience, investment or not, in the Republic of Kaylia?
No, I believe it's referred to in the case facts that he's had conversations with investors about further expansion. And obviously there's a lot of published research about the need for investment in Kaylia, but had he specifically invested prior to this? No, not to my knowledge.
Would you agree that Mr. Peters' experience has previously been in Western Europe or limited to Western Europe?
UK and Western Europe. Yes, that's right.
Would you say that there is an economic difference between countries in Western Europe and the UK and more recently developing countries like the Republic of Kaylia?
That's an incredibly broad question. Different in some respects, similar in others. So you need to be more specific.
Are there different risks involved with investing in an emerging economy?
Broadly speaking, sure. Risks and opportunities. Obviously, the Republic of Kaylia had an enormous growth rate, hence the foreign investment, which is a great opportunity.
Would you say there are differences in investing in competitive and regulatory environments such as Kaylia?
Well, certainly Circular 10 caused a bit of an issue, yes.
So on page, let's turn to page 4 of the report.
Yeah.
Just go back.
I'm there.
Do you see the sentence that starts with whilst numerous market commentators on that's paragraph?
Paragraph 10, second last line. Yep.
Yeah. Would you agree that the Republic of Kaylia would be considered, let's say, a riskier economy than that of Western Europe and the UK?
Again, risk is a relative term, but the sentence you've just taken me to suggests that there was rapid growth, need for rapid investment in the social infrastructure in order to provide the skilled labor and wider infrastructure. That to me suggests nothing to do with risk and more to do with opportunity that existed in the developing nation.
I'm sorry, Counsel. I wasn't quite at the page that you had directed, and I don't appear to be at that page. Could you confirm for me what page we're on?
Page 4.
Page 4.
And with page 4 to page 5.
For some reason, I thought you said 24.
So that's on the next page, that's paragraph 11.
Yes.
Says potential new investors in Kaylia also recognize this challenge. You describe the challenge that you're describing.
Well, there's a gap between the level of investment currently being made or that was being made at that time in Kaylia and what was required to realize its potential. The challenge was raising capital, which Mr. Peters stepped up to fill part of the gap.
So based on that statement, there are different challenges or like risk factors involved in investing in the Republic of Kaylia? Is that what you're saying?
No, what I'm saying is that there was a challenge finding sufficient foreign investment capital to realize the potential of the Kaylian economy. And that challenge was met through foreign direct investment, including in part Mr. Peters' investment.
Would the Republic of Kaylia then be considered a potentially more volatile market for investments?
I'm going to go down this path with you. Sure. Yes.
In that case, in reviewing the feasibility study, would you say then the claimant was aware of the growth and changes occurring at Kaylia at the time prior to the investment?
Growth, yes, certainly. It's part of the reason for making the investment in the first place.
Now turning to page 13.
I'm on 13.
And specifically paragraph 42.
Yes.
You state that, quote, Mr. Peters, that the degree of certainty and I understand from Mr. Peters that the degree of uncertainty in projecting the revenues and costs of an international learning center project is limited, since the economic structure of such operations is standard. Just on the statement alone, is there anything about investing in let's say, a nation such as Kaylia that you would consider standard? Or what were you referring to in this sentence?
So this sentence refers to the operation of an educational institution, which I think we've all been to school before. It's the same degrees and classes and tests and certification process. Mr. Peters is clearly an expert in that, having done it many times successfully. To your question, if there's anything that's not standard about an investment in Kaylia, sure, the market is a new one for LearnFast. And there's a certain degree of uncertainty and unknowns there.
On the sentence, maybe it's my grammar focus, but I'm a little confused. So the degree of uncertainty is limited. Wouldn't that mean that the degree of certainty is endless? Is that what you meant?
No, that's sorry, and I apologize. I mean to suggest from this sentence that there is some uncertainty, but use of the term limited is meant to suggest a modest amount.
Okay, thank you.
Yeah. Your grammar's accurate though.
So turning to page 21 of your report. Starts with B, determination of NPV.
Yes. I was waiting for the math.
So in your determination of NPV, or net present value of the Caton City project, you use a discounted rate of 10%.
That is correct.
And this rate was based upon Professor Demordarin's, was that right?
Yeah,
9%.
Demodarin or Damodarin. Yeah.
9% weighted average cost of capital for the educational services industry in the 2000s.
That's right. Yes.
So you applied a 1% country risk premium.
I see your math. It's actually a combination of increases and decreases. So if the industry as a whole were a 9% cost to capital, I would argue that LearnFast, the UK entity at least, is something less than that, having been a well-established and successful business. So for the sake of illustration, say LearnFast UK may have been 7 or 8. I'd apply a premium of a couple percent on top of that for the unknowabilities of the Kaylian market, combined with the opportunities, of course.
Did you benchmark this rate against risks specific to investments in the Republic of Kaylia?
I did not.
Did you use, and you said something.
Sorry, Counsel. What do you mean by investments? I understand that we're talking about the performance of a hypothetical enterprise.
Right.
Is that to be distinguished from an investment, or is the enterprise an investment?
It would be the enterprise and the investment.
Okay, so perhaps could you put that question again to the witness?
Did you benchmark this rate against risks specific to enterprises and or investments in developing countries or in the Republic of Kaylia?
So clearly there is no comparable enterprise or investment in the Republic of Kaylia at the moment that would be a suitable benchmark. One thing perhaps I could have done is to have looked at the rates of return earned on government bonds or other, more standard vanilla investments to see how they compare with the UK. And perhaps a premium on those kind of instruments might be appropriate here.
Okay, Mr. Smith, I'm going to turn to a bit about the network project.
Yes.
You state that the Caton City project was intended to serve as the foundation for the network project.
That's my understanding, yes.
Could you tell us or point to any formal agreements or contracts that had committed LearnFast to the network expansion?
At the time of the breach, there were no formal agreements in place.
There weren't any agreements?
At the time of the breach, some subsequently were issued in the form of a license in 05 or 06. I forget the exact date. You'll have to ask Mr. Peters because I believe it was an oral agreement.
Okay, so we don't have any written agreements that committed LearnFast to the expansion?
Absolutely right, yes.
And
At the date of the breach.
you don't have any evidence of any finalized investment licenses or regulatory approvals for the additional locations, correct?
At the date of the breach, they did not exist. Although, of course,
So yeah, we're referring to the,
purely to the network, right? Only on the base project were such approvals and licenses received.
would you also agree that without any investment licenses or approvals at the time that we are discussing, network project was aspirational?
No, I'm not sure I'd use the term aspirational. It was planned. The licenses for the network specifically were not in place, but the base project existed. And it's, I think, a reasonable jumping off point to assume if that project had been successful, similar license were possible.
So we're talking about the actual project, but here we're referring to the network project for the expansion.
I agree with you. I think we're on the same page aside from the use of the term aspirational.
Okay. Well, we're referring specifically to the network project, which is referring to the expansion. Were there any concrete steps taken in finalizing plans for this expansion?
Could you give me an example of what kind of concrete step you might be thinking of?
Again, referring to any sort of approvals or contracts, licenses of the sort. Was there anything like that?
At that date, no. I believe Mr. Peters was focused on the success of the initial venture.
And did LearnFast complete any feasibility studies for the proposed additional learning centers?
Ultimately, they did, yes, but not at the date of the breach.
Okay. We're referring again to the expansion, the network.
Right, yeah. They were subsequently prepared.
Can you turn to paragraph 85 of your report, please?
Yes.
Well, in paragraph 85, you state that business plans were completed.
That's right.
However, in subsection C, you also write that the feasibility study was not completed.
That's right, yes.
And below that, it says that the investment license was not granted.
That's right. They were still pending at that point.
So if no feasibility studies were conducted, how can you, I guess, confidently project that the success or the success or profitability of the network project?
Well, on a combination of a couple of different things. One, Mr. Peters is well established as being a great forecaster. He has a history of doing that with his core business. The base project itself, even subsequent to the implementation of Circular 10, was about break even. So if we accept the reasonable proposition that Circular 10 had some negative impact on the base project, it certainly would have been profitable. And if the base project were to be profitable, I see no reason why an expansion of those enterprises would not have been profitable.
But you agree that there wasn't any feasibility study done on the expansion?
Well, I think the distinction between a feasibility study and a business plan is marginal. Frankly, I'd be more interested in the business plan for viability.
Well, in a feasibility study is where you would see projected revenues, correct?
Correct.
And the costs.
I would also expect those to be in the business plan. The feasibility study, as it says earlier in the documents, was predominantly for the purposes of getting that license from the government, not necessarily for internal go, no-go investment decisions.
But the feasibility study that you're referring to previously was conducted in 2000, right?
Sorry, could you repeat that?
The feasibility study that you were referring to was from 2000.
Yes, for the initial project.
We are talking about 6 years later and talking about the network.
Right, and I'm assuming that the purpose of the feasibility project in 2006 was exactly the same as the purpose of the feasibility study in
You don't think
2000.
that the country, a developing country such as Kaylia, has changed in 6 years?
Oh, I expect it would have, yeah.
Counsel, the tribunal secretary tells me you have 5 minutes.
Okay, thank you. Were there any, there weren't any financial commitments or secured funding from investors or banks to support the network project?
Secured, no. Conversations had occurred with interested investors.
But there were no written commitments or agreements, correct?
No,
Thanks.
it's reasonable to assume that the imposition of Circular 10 would have had an impact on the ability to raise capital for that business.
Did LearnFest have any operational capacity in terms of management or resources to scale its operations across multiple locations?
You'd have to ask Mr. Peters that question.
Okay. And again, there was no feasibility study that would have discussed this, correct?
Simply a business plan.
And given that the Caton project was already operating at a loss, do you have any evidence to support that LearnFast's ability to successfully expand?
Absolutely. So if the existing business was operating, as I said, at a marginal, it's really more break even, and that was subsequent to the Circular 10 impact, if any adjustment, any modest adjustment for the impact of Circular 10 would have restored the base project to profitability. And I see no reason why an expansion of that base project, with all the learning and experience that had come before, would have not resulted in similar profitable enterprises.
Okay, turning to the 10% discount rate that you applied with the DCF discount cash flow.
Yes,
This was again based on the same discount rate that we discussed earlier from Professor DeMondraon's standard.
right, with a probability factor overlaid.
The probability factor being 20 to 50%.
That's right, yes.
Was there any empirical study or evidence that you have to support that the 1% would, the addition that you had, would take into consideration Kaylia's developing economy?
No, it wasn't an adjustment to reflect the risk of the economy specifically. That's better captured in the discount rate. The 20 to 50% probability weightings are, as I say in my report, a measure of the earlier stage of planning of the network. So many of the questions you've just asked are about sort of the state of the network initiative at the date of breach. And I recognize there's a greater degree of uncertainty there. So I've reduced the value by something in the order of 20 to 50% to reflect that uncertainty. That's not.
Were these numbers based off of any standard or empirical study?
No, there's a degree of subjectivity there. And
Mr. Smith, did you want to finish the answer to the
Sorry.
previous question?
well, only to say that the 20 to 50% probability weightings, they're comparable to weightings I've used in other matters.
Did you ever use those numbers in a country similar to Kaylia that was a developing country?
Not identical to Kaylia, but similar, yes.
Similar in terms of, was it a Western economy or?
Central Europe, yes.
Did this 20 to 50% take into consideration the risk factors, once again, with the economic volatility of Kaylia?
No, that was predominantly captured in the discount rate. The 20 to 50% is just the early stage of the commercialization.
Did that number also account for any potential downturns in foreign investment or GDP growth?
No, those sort of some systemic risks are in the discount rate as well.
So just to confirm, there weren't any foundational steps taken, such as securing licenses or feasibility studies for expansion of the network project?
At the date of the breach, that's correct, yes.
That's all for us. Thank you.
Thank you. Mr. Smith, would you like a potty break?
Would I think I can wait for redirect.
Okay.
Yeah.
Counsel?
Sure. I'm just gonna grab the microphone.
Oh, I thought she was going to do a,
Sorry.
dynamic American style.
Mr. Smith, you were asked about certain documents that you did not review in order to calculate the compensation value of claimants' investments in the Caton City project. And you explained that you did review LearnFast UK financial statements, which contained an unqualified audit opinion. Could you please briefly explain the relevance of this document in your analysis regarding the short-term loans that are described in LearnFast Kaylia's 2005 financial statements?
Gladly, and just for clarity, we're talking about the UK audited financials. Okay, so as I said briefly before, every transaction has two sides, a lender and a borrower. And in this instance, the borrower, LearnFast Kaylia, has qualified financial statements, reasonably so, I believe, because the auditor was unable to get their hands on the underlying invoices and other things that respondents' counsel pointed to. Those documents are in possession of affiliates of the respondent, the Kaylian government, and were not produced despite our requests for those documents. In the absence of that kind of support, and given the qualification on the borrower's financial statements, we looked to the other side of the transaction, the lender, which is LearnFast UK in this case, where documents were available. No such qualifications exist on the lender side, on the financial statements, and the auditors were fully satisfied that those loans existed and in the amounts indicated on both sets of financial statements. Thank you.
Thank you, Mr. Smith. Just one more question. You were asked several questions about risk levels in Kaylia, but you also touched on the opportunities that were present in Kaylia. Could you expand a bit on that and tell us about the country conditions that present an attractive opportunity in Kaylia?
Sure. How long do I have?
2 minutes.
Yeah. At a very, very high level, every country, every investment opportunity is a balance of opportunities and risks. Certainly, Respondents' Counsel has made some very good points about a nascent developing economy and uncertainties that exist, which would, all other things being equal, increase the degree of caution and risk one applies when looking at investment in that industry. However, counterbalancing that is the tremendous opportunities and growth that were referenced a number of times by independent investment banks and studies, indicating that this is a fast-growing economy and investments were likely to do very, very well. So while there was great risk, there was also great opportunity. And you need to balance those two things when assessing the credibility of Mr. Peters' forecast. Mr. Peters' forecast was based on Western economy learning institutions, which exhibited perhaps not the risks, but certainly not the opportunities available in Kaylia. And I would argue that the two factors sort of cancel each other out in terms of determining whether his forecasts were reasonable.
Questions?
So just a general question with respect to valuation standards. Could you point me to a document that would demonstrate that a discounted cash flow method, and specifically the discount part, would also include an opportunity part?
It would also include an opportunity part. Yes. So this is Demo Darren again. The opportunity part really finds its way into the discount rate in the growth factor, which kind of comes towards the end of the discounted cash flow. So the forecasts will reflect a certain amount of growth over the explicit time period, 3, 4, 5, 10%, whatever it is. And in the terminal value, the final year of a discounted cash flow, there is a perpetual growth factor applied to the discounted the cost of capital. That's sort of synonymous with the opportunity of that market.
Okay. Thank you. Let's see here. So you are released. Thank you very much for your time, Mr. Smith. So now we're going to hear, pretend that we just had a break. Now we're going to hear from respondents expert. Is he in the room? Or she, sorry, or they? Good morning.
Good morning.
Is your name also Smith? What a coincidence.
Chris Brown. I gotta flip that. Oh,
Aha.
this is not Kanye.
Good morning, Mr. Brown. Counsel for the claimants are going to have some questions for you. The tribunal may have some questions as well, and there'll also be a short rebuttal period by which the or redirect period, and by which counsel for respondent may have some additional questions for you that follow upon something that the claimant might have raised. So with that, please go ahead, claimant.
Good morning, Mr. Brown. My name is Carolina Catanzano, and together with my colleague Clark Orr, we represent Learn Fast UK in this arbitration.
Good morning.
We will be conducting your cross-examination today, and we will be asking you some questions on the matters that you discussed in your expert report. I'll ask you to please listen carefully to the questions so you can answer to what is being asked. And if there is a question that you don't understand, please let us know and we will repeat it. Now, in paragraph 1.1 of your report, you state that you have acted as an accounting expert witness on 20 occasions, correct?
That is correct.
And have you ever quantified damages as an expert witness before?
Yes, I have.
And have you ever valued businesses as an expert witness before?
I have, yes.
But you don't mention those facts in your report, correct?
Paragraph 1.1 that you refer to is a very high-level summary. It does not include extensive details on my full CV, no.
If you could please turn now to paragraph 1.2 of your report. Here you set out the instructions that you received from the counsel, correct?
That is correct.
And you were instructed to prepare a report, or reply report to
So
the
what page are
expert.
we on, counsel?
It's page 1,
Thank you.
paragraph 1.2. So you were instructed to prepare this reply report in response to Mr. Sam Smith's expert report, and you address the compensation value under 3 separate heads of claim, right?
Correct.
Very well. I would like us to focus now on the first head of claim, the compensation value for the investment made by Learn Fast UK in the Caton City project. And I would like us to go to table 1 of Mr. Smith's report that is on page 10.
Okay.
So there we see that Learn Fast Kaylia's 2005 audited financial statements show, on the one hand, unrepaid borrowings from claimant for $779,000 Kaylian plus accrued interest. And on the other hand, the capital contribution that was paid by claimant into Learn Fast Kaylia for $400,000. Do you see that?
I do.
And now, if we go to paragraph 3.3 of your report, you,
On what page, counsel?
page 3.
3.3 on page 3.
It's page 5.
Thank
sorry.
you.
Page 5.
And the witness, you're there too?
Yes, I'm with you.
So in paragraph 3.3, you mentioned that Learn Fast Kaylia's 2005 financial statements cannot be relied upon because they were qualified by auditors in relation to the company's recorded borrowings and accounts payable balances, correct?
Correct.
And these borrowings are recorded as short-term loans in Learn Fast Kaylia's financial statements, correct?
That is my understanding, yes.
And short-term loans in the financial statements represent liabilities that Learn Fast Kaylia is expected to repay, right?
That's what the account and the presentation would suggest. Whether that is in fact the case is a separate matter.
In general, in terms of financial statements, loans would be liabilities in a financial statement.
Correct. That's what a number in that line item would suggest, that it's an amount to be repaid.
Now, legal capital is not considered a liability in the financial statements, correct?
Correct.
So legal capital is part of the company's equity and is thus recorded as a separate line item in the financial statement, right?
I agree with that, yes.
So you would agree with me that the auditor's partially qualified opinion relates only to liabilities, in this case, borrowings and accounts payables, but it does not relate to legal capital, correct?
I agree. Their note, I think, sufficiently isolates the concern to evidence surrounding the $515,000 loan for which they were unable to obtain any evidence.
So there is no reason then to think that the 400,000 Canadian dollars under the legal capital item in Learn Fast Kailia's 2005 financial statement is unsupported, correct?
Not that I'm aware of, no.
Very well. Going back to the short-term loans, in paragraph 3.4 of your report, which is also in page 5, you state that given the auditor's qualified report, I do not consider the 2005 financial statements provide sufficient evidence to substantiate all of the 779,000 Canadian dollars of the claimant's alleged loans to Learn Fast Kaylia. Correct?
Correct.
And then in paragraph 3.5, you mentioned that claimant has not provided any additional evidence to confirm that loan capital was given to Learn Fast Kaylia, correct?
Correct.
Mr. Brown, you have reviewed claimant's audited financial statements for the preparation of your report.
I have.
Correct? And claimant's audited financial statements do not contain any qualification to the audit opinion, right?
I'm sorry, can you clarify whose audited statements are you referring to?
Claimants, Learn Fast UK.
The UK entity.
Yes.
That is my understanding, correct?
Now, you are aware that claimant's 2005 audited financial statements show a loan to Learn Fast Kaylia of 779,000 Canadian dollars, right?
That's my understanding, yes.
And this loan is consistent with the loan value that is recorded in Learn Fast Kailia's own 2005 financial statements, correct?
I'm sorry, could you restate the question?
Yes. This loan amount that figures in claimant's audited financial statement is consistent with the loan value that is also recorded in Learn Fast Kailia's 2005 financial statements, correct?
Yes, correct.
But yet you do not address these facts in your expert report, correct?
No, in my report, I address the more salient point. I think that within the country of Kaylia and within the Kaylia specific financials, the auditors who were tasked with specifically reviewing that amount found no evidence. And so while that's not necessarily evidence to the contrary, I find it concerning that they were unable to get that comfort, not just in a single year, but after multiple years. So I understand the point that in the UK unqualified financials, it is reported, but in the Kaylia specific financials, the auditors were unable to get that evidence.
I have a couple of questions. Mr. Brown, the first one is again on paragraph 3.4. You say that you do not consider the 2005 financial statements to provide sufficient evidence to substantiate all of the 779,000. Is there a part of it that you do feel has been substantiated?
Yes, so referring to the auditor specific qualification, they state that for 515,000, they were not able to obtain evidence. By default, the remainder, I've accepted that they were able to obtain sufficient evidence. So the net difference between that 250,000, give or take.
And help me out here. We heard claimant's witness explain that he was satisfied with the audited statements of the loaning entity, recognizing that the auditors had recognized that there had been a loan. Why is that not sufficient to you?
Well, there's really two components to this piece of the head of claim. One is what amount of funds might have been inserted into the system, which is what we're talking about now. That's relevant to me. A more salient point is which of those funds, if any, were actually invested in the project, which is an entirely separate line of questioning. And so while we're talking about some uncertainty around the amounts of loans and what actually was received into Kaylia, most of what I then focus on my report is the evidence that I considered as to what amounts, if any, were actually expended in the effort of building that project.
And how much auditing experience do you have?
I'm a certified public accountant, and the early years of my career, I served as an auditor.
Because I'm just curious, I got the sense from the previous witness that a distinction is to be drawn between the auditor's role and the evaluator's role, and that the evaluator should be allowed to rely upon an auditor contemporaneous in the time making decisions rather than want to look behind what the auditor did. And it seems like you're looking behind what the auditor did. Is that a function of the fact that you used to be an auditor?
No, I agree with the point that auditors have their role, and as experts, we may rely on the auditors. What I'm saying is something slightly different. Let's take as granted that the loan amount is as stated in the UK financials. Well, if we accept that as a fact based on the UK audit, my primary point in my report is something separate, that there's a separate question of if that was the full amount of the loan, how much of that was actually invested in the project versus wasted, absconded, or otherwise. That to me is the more salient question as to what amount of capital was actually invested, not merely what amount was loaned from one entity to the other.
Please proceed.
And if we turn now to paragraph 3.8 of your report, which is on page 7. You explain that you have quantified claimants' investment by reference to the value of assets purchased and expenses incurred by Laird Kaylia that were stated to have been paid with funds provided by the claimant, correct?
Correct.
And then in paragraph 3.10 of your report, you know that you found support in Laird Kaylia's 2005 financial statements for $763,000 Canadian dollars of shareholder-funded capital that was invested in fixed assets, setup expenses, and building deposit, correct?
Yes, but if that warrants some qualification, I wouldn't characterize it as support or evidence. What I've attempted to do with the limited information I had available to me, which for the avoidance of doubt excluded access to actual project invoices, payment records, or receipts that would show funds being expended in the Caton project. What I attempted to do in my analysis was to consider the evidence available, which, as you know, suggested that an amount of 763 appears to have been invested in the project, which I observe is less than the 1.2 million set forth in the Smith report.
Correct, but in that same paragraph, you also recognize, and I quote, that there may have been other expenses funded through capital provided by the claimant. End of quote. Do you see that?
I agree. There may be additional evidence, but I have not been able to review any of that or have not been provided that evidence.
So you acknowledge that your analysis of assets and expenses incurred by Laird Kaylia is not comprehensive, and there may have been other expenses funded through claimant's investment that you have not been able to identify, correct?
The primary purpose of my report is to respond to Mr. Smith. He also has not reviewed any such evidence. I've attempted to do a more robust analysis with the evidence I do have, but I do acknowledge that there is a limitation.
But you were aware that Laird Kaylia filed for bankruptcy and entered into liquidation in 2006, which has severely restricted claimants' access to Laird Kaylia's documents and records, right?
I'm familiar with the bankruptcy to the extent documents are limited in their access. I'm not familiar.
But were you or were you not aware that the joint jury, one of which is a member of the Kaylian Department of Finance, refused to provide access to Laird Kaylia's underlying financial records and books?
That's my understanding, yes.
So you would agree with me then that in the absence of the underlying financial records and books, it is difficult to verify all of the expenses incurred by Laird Kaylia with funds that were provided by the claimant, correct?
I agree. I think both Mr. Smith and I have been hampered somewhat by the inability to access all of the documents that might have been helpful in this analysis.
Thank you, Mr.
Sorry, just to be sure, so you didn't see any of these documents?
No.
Are you aware of their existence?
To my understanding, as was just discussed, access to them was withheld and not available for myself nor Mr. Brown.
But it means there is a them.
Mr. Smith, sorry?
But it means there is a them.
What exactly exists in those documents, I think, is the fundamental underlying question.
Did you ask to see those documents?
I did, but again, my understanding was broadly they would not be available.
Okay, but you did ask for them.
Yes, I did.
You just didn't get them.
Correct. I relied on.
And you do think they exist.
I have no reason to believe they don't exist, but what might be in the financial records that are now behind a wall of bankruptcy, I can't say one way or another what might be in those documents.
Okay, thank you.
Thank you, Mr. Brown. I have no further questions, but my colleague will continue with your cross-examination.
Morning, Mr. Brown. My name is Clark Orr. How are you?
Well, thank you.
Great. I'd like to turn to some questions on the second head of claim relating to the losses on the Caton City project. So you and Mr. Smith have both discussed at length the 2000 feasibility study prepared by Mr. Peters. I'd like to begin there. You're aware that the 2000 feasibility study was prepared prior to LearnFast submitting its investment license to set up LearnFast Kaylia, which was submitted on 20 May 2000, right?
Correct. It was developed prior to the actual project kicking off and was not updated in any of the subsequent years after 2000. That's my understanding.
And you're aware that Circular 10 was issued on 22 May 2001, which is more than a year after the 2000 feasibility study had been prepared, right?
Correct.
Right. And you're aware that Circular 10 is the subject of this dispute, the measure that claimant argues has breached the investment treaty, right?
I understand the allegation that Circular 10 caused the business to not perform as well as forecast.
There's no indication that the 2000 feasibility study was prepared for the purposes of arbitration or anticipation of a dispute, right?
I don't know that I could say one way or another, but I'll accept your point.
And because it was prepared well in advance of Circular 10, the projections in the 2000 feasibility study do not reflect any changes to revenues, costs, or profits as a result of Circular 10, right?
Well, I think that's a great point. In my experience dealing with feasibility studies, budgets, business plans, one might have expected that post Circular 10, there might have been any needed revisions for that reason or for any other operating reality. But I agree that after Circular 10, I'm not aware that Mr. Peters made any updates to the feasibility study or prepared any other budgets or business plans, but that would be a good question for him.
So in other words, Circular 10 serves as a projection of the but-for scenario. The study contains projections, revenues, costs, and profits, but for the introduction of Circular 10. Is that right?
I think you misspoke at the outset. I think you mean the 2000 feasibility studies
The
that
2000
served as a but-for.
Apologies. Yes, that is what I meant. The 2000 feasibility study serves as a projection of the but-for scenario.
I understand that that's what Mr. Peters hoped to attain from the project. I further understand that Mr. Smith has adopted the feasibility study as the basis for the primary basis for his but-for analysis. Yes.
Well, then we're on the same page.
Okay.
So you note that the 2000 feasibility study is based on Mr. Peters' data and experience running learning centers in the UK and Western Europe. Is that right?
I understand that's the basis. As I note in my report, it's unclear to me how he may have adjusted for Kaylia specific conditions.
So you're aware that according to Mr. Peters, those learning centers in the UK and Western Europe typically generate a profit margin of around 80%, right?
That's consistent with my understanding from the reports of how the UK and Western Europe have performed, yes.
And this profit margin of 80% is close to the estimated long-term gross profit margin of 82%, which is projected in the 2000 feasibility study, right?
That's my understanding, yes.
And are you aware that Kaylia is a rapidly developing country with a population of around 18% of its population aged 16 years and below?
Yes, that's my general understanding.
And are you aware that Kaylia, at the time this project was introduced, is experiencing GDP growth averaging around 10% per year?
Correct. That's my understanding.
I'd like to turn to paragraph 5 of the Smith report, where you will find a quote given by the president of United Global Bank in 2001. The quote reads, in relevant part, I see Kaylia as one of the key growth markets for our business. Its location and investment incentives mean that it's a hugely attractive opportunity. We, like so many others, are continually increasing our presence there. However, we are rapidly reaching a point where our demand for skilled and educated labor cannot be met by this country's population. And it goes on to state that Kaylia needs an urgent improvement in the quality and volume of education in the country so that its future labor force can fill the huge labor demand gaps, which will soon appear in Kaylia. Do you see that?
Yes, I do.
And are you aware that when Mr. Peters was planning this investment, Kaylia's educational system was focused solely on local students?
That's my understanding from his feasibility study, yes, that there was an opportunity to expand.
And that opportunity in particular was that Mr. Peters' planned learning center would target both local and international students.
A small portion of his forecast reflects attracting foreign students. That's correct.
In light of this evidence, is it fair to project that Kaylia presented a more favorable conditions of demand and market competition for learning centers than the UK and Western Europe?
That's a very broad question. Does Kaylia present a more favorable opportunity than the UK or Western Europe?
Just to clarify, I specifically said with respect to demand and market competition.
It's a good question. I haven't conducted a study of the educational growth opportunities at the same time in the UK and Western Europe. I suppose that could be done, but I don't deny that Kaylia, for the reasons you've cited and the quote you shared, and that appears in Mr. Smith's report, Kaylia presented an investment opportunity. And I don't deny that Mr. Peters, based on his experience, saw that opportunity and was attempting to seize on that opportunity. Whether it's better or worse than other opportunities in other countries is beyond the scope of my analysis.
And at least based on the evidence that we've just reviewed with respect to demand and with respect to market competition for education services, would it not be reasonable to expect the data from Western Europe would yield conservative projections of demand and market competition when applied to the Kaylian market?
Again, I think it's a phenomenal question. And as I point out in my report, that type of inquiry is exactly what I found to be lacking in Mr. Smith's report, with all due respect. Whether there was any robust testing of the underlying assumptions for the Kaylia forecasts vis-a-vis UK or Western Europe. For example, while there is a great need, what are the abilities to hire the right talent to actually support learning centers, whether foreign or local based in the state of Kaylia? Those considerations, in my view, were lacking in the feasibility study, but I think they're great questions, because I do think that part of this, the whole deficiency here I find in the claimant's loss analysis is the failure to consider operating realities in one economy compared to the emerging economy of Kaylia.
Okay, so I'd like to turn to paragraph 410 of your report. And that is on, I'll give you the page in just a moment. That's on page 10.
Okay.
You argue in your report that the gross profit margin projected in the 2004 feasibility study is essentially unrealistic, and the claimants have not explained why that gross profit margin would be significantly higher than the actual gross profit margin that was achieved. Is that right?
That's correct. As I mentioned a moment ago, after 2000, to my knowledge, that gross profit margin assumption was never revisited despite delays in projects, circular 10 or otherwise. So I don't find any evidence that those assumed profit margins were at all tested for local conditions.
Okay. And gross profit margin, you explain in paragraph 4.9 is the difference between revenues from lessons being delivered and the direct cost of achieving those revenues, right?
Correct.
I'd like to talk about those costs and revenues specifically. So you acknowledge that as a result of circular 10 quotes, and this is in paragraph 410, there may have been some incremental one-off costs in year one as certain materials were prepared for school. Do you see that?
I do.
And claimant has stated that prior to circular 10, claimant planned to use educational materials adapted from pre-existing materials, and that new materials had to be substantially revised to comply with the standards in circular 10. Do you contest that specific claim in your report?
It's not a matter of contesting the claim. It's a matter of if there were incremental costs to update materials, I haven't seen evidence of what that might have been. However, I would expect a large degree of overlap between local learning requirements and foreign requirements in general. So as I note, I expect there might have been some additional costs. I would not have expected them to be significant. If they had been significant, I would have expected to see some evidence or testimony from Mr. Peters to that effect.
Beware the claimant has stated that additional equipment was required as a result of Circular 10.
As I sit here, not specifically, but I might be reminded.
Sure, that is in paragraph 1.22 of the claim summary, and I'll just quote it for you.
Thank you.
Just a moment here. Right, so claimant alleges that it incurred incremental costs as a result of the requirement to operate as a school that were not planned in the 2000 feasibility study, including, quote, the acquisition of additional equipment.
Thank you.
Great, thank you. And you don't contest that specific claim in your report?
I don't, but again, I don't have any evidence to quantify what that investment may have been.
So sorry to interrupt, the tribunal secretary has been waving at me. You have 3 minutes left.
3 minutes, got it, thank you. So you also wrote that in paragraph 410 of your report, it is not clear to me why Circular 10 would require the school to incur significantly higher payroll costs. Do you recall that?
Yes.
Great. And when you wrote that, were you aware that Circular 10 required higher levels of staffing at the school as compared to at a learning center?
I'm not familiar with that requirement.
Do you contest that requirement directly in your report?
Again, my report responds to Mr. Smith, and I don't see that there's discussion of higher staffing requirements based on Circular 10 discussed in his report.
So on paragraph 67 of Mr. Smith's report, he states, and I quote, "The number of staff and payroll were subject to changes as the Kaylia Department of Education requirements under Circular 10 required higher levels of staffing at the school as compared to a learning center." End quote. Do you see that?
I do. Again, it's not a quantified effect, but I understand the point that there may have been higher levels of staffing.
Okay, and turning to revenues, Mr. Smith demonstrated that the main difference between the projected revenues and actual revenues is that the price per lesson for Kaylian students are 10% lower than forecast, whereas the price per lesson for international students was 33% lower than forecast in the 2000 feasibility study. Were you aware of that?
Yes, I was aware of that aspect of the analysis.
And are you aware the claimant has alleged that the introduction of Circular 10 and the transition from a learning center to a school under those regulations made the proposition less appealing to international students, meaning that LearnFast Kaylia was unable to charge premium prices for the lessons offered? Are you aware that claimant has alleged that?
I'm aware of that allegation. As summarized in the Smith report, the relative percentage of foreign students pre or post Circular 10 does not appear to be a large difference. It's plus or minus a few percent.
So the difference is that Mr. Smith alleges is in relation to the price that they were able to charge, not the number of students.
No, it's the number of students.
No, I don't believe that's correct. We can turn to Appendix 3 of Mr. Smith's report. Which is the second to last appendix given. And so you can see price per lesson in the second grouping of projections, and you can see forecast versus actual. And at each point, the forecast is 150 and the actual is 33% lower at 100, right?
I think we might both be correct. You're referring to the quantity of lessons. I'm referring to the top half of that exhibit, in which you can see the number of Kaylian students estimated at 85% when it's actually 88%, so on and so forth.
Okay. So just to sum up this discussion of costs and revenues, which ultimately determine the gross profit margin, claimant has explained that Circular 10 resulted in higher costs of preparing education materials, higher costs of equipment, higher labor costs, and lower prices per lesson, and you don't directly contest any of that specific evidence in your report. Is that an accurate summary of what we've just covered?
In summary, I don't think that the feasibility study is a valid benchmark. I think it's overly optimistic, and it's an unsupported and speculative basis for measuring against the actual results. I don't deny that there might have been additional costs, but I don't see any robust calculations as to what specifically those might have been.
Just to follow up on that last question. What value do you assign to the fact that a document is contemporaneous to the events in question? Apart from anything else?
Yeah, I accept the point. I think it's a good point that the 2000 feasibility study was prepared not in anticipation of a legal proceeding. It was intended to highlight an opportunity and an investment to get licenses within the country of Kaylia. However, what might initially be set under a plan, in my experience, is subject to constant iteration and revision as one embarks on a project. Management often makes monthly, if not quarterly at least, updates to budgets and forecasts. To me, it strikes me as odd that in this case, the damage analysis proffered by the claimant is anchored to the original investment thesis without any further learnings, knowledge, or know-how once the project started, even before Circular 10. It was never updated, never revised. And there are critical assumptions, most notably the margins that one might attain in Kaylia were never revised. And now we're led to believe that it's all due to Circular 10. There may be some incremental costs, but my primary point is the evidence is lacking that Circular 10 caused those costs versus a bust, if you may, in the original feasibility study.
That question though, causation, that's not really the valuation expert's role, is it?
I'm not commenting. It's a great point. I'm not commenting on causation. I'm really observing that operating conditions in UK and Western Europe, which informed the initial estimates for gross margin, that's my understanding for how the feasibility study was constructed. Those gross margin assumptions were never revisited, to my knowledge, after the initial feasibility study. And I think that to me is what is striking here, that operating conditions, we don't have the testimony. Mr. Peters might have to comment on operating realities in Kaylia and why they're different. I don't see any evidence that the Smith report considers the fact that despite maybe slightly higher headcount, why the operating costs in Kaylia should mirror exactly what was experienced previously in the UK and Western Europe.
Okay. Any follow-up on that? Okay. Counsel?
You said that the purpose of your report was to respond to Mr. Smith's report.
Correct.
Claimant's counsel asked you whether the absence of underlying financial statements made it, I think the term was, difficult to assess any loss, right?
Something to that effect, yes.
Can you please clarify how, let's say, Mr. Smith could have accounted for the difficulty in the absence of underlying financial statements?
In other words, as I discussed in my report, to overcome the qualification in the audit, I note a few ideas, including certain public records that I understand are required to be maintained in Kaylia regarding registration of foreign loans, so on and so forth. While there might be avenues to conduct that research and perform that study to shore up some of those deficiencies or qualifications in the audit, I don't see that those avenues were considered to cure the deficiency in the documents available.
You also use a different model to assess the NPV of the Caton City project?
Correct.
How does, let's say, your model differ, or your proposed model differ from that of Mr. Smith's DCF method?
Yeah, I should clarify. The model or the tool, the discounted cash flow model or tool is the same. But in my report, I try to isolate the effect of certain key inputs and assumptions that are critical if the output of that model or tool is to be reliable. Most notably is the discount rate, for which Mr. Smith has given his basis that he used a 10% discount rate based off of a US study. In my report, Appendix 14, I set out a buildup of the weighted average cost of capital in the standard fashion, adopting the modified capital asset pricing model, accounting for risk-free rates and premia for country-specific and other entity risk. That implies, in my opinion, a much higher discount rate, which all else equal, as I summarize my report, would reduce the damage even under similar sets of assumptions as set forth by Mr. Smith.
I think to the very last point, you were asked about referring to the number of lessons and the number of students in the analysis of the forecasted revenue. You explained that there were discrepancies in Mr. Smith's calculation.
Not discrepancies in the calculation per se, but if there's an allegation that the school had hoped to attract a higher number of foreign or international students, Appendix 3 to his report does not suggest that they attracted any fewer international students. The international students showed up in approximately the numbers expected. I think the point that was discussed was whether those students were paying the rate that Mr. Peters expected they might pay compared to what they actually paid.
Thank you. Well, we've had a productive day. Thank you very much to the two witnesses. We'll adjourn for today, and we will then move on to the closing statements by counsel tomorrow, which actually means 10:55.
Yeah.
So now we're in our break.
Eight.
This was a really good idea.
Yeah.
Yeah, great. Thanks so much. Great job. Thank you.
Take this home.
Some of those things.
Exactly.
Glad to hear it. Glad to hear it. You were excellent. We were trying to come up with things for redirect just to say
Changing my.
And it was effective. Like, that kind of redirect is like, could you just reinforce something you wanted to say? Because I think it's a really strong point. Literally.
Sorry, I'm just gonna move this a little bit this way. What this will move to? Just a little bit forward.
So you want to see more of my bald head?
The audience is demanding to see it.
You see the rest of my bald head? Good, good, good.
Got a full-
So it was pretty good. I think only twice did I not turn it off for a cough.
Yeah.
It was pretty
Can I
good.
use the bathroom?
Yeah.
Totally, yeah.
Right back.
Okay, so current closings now, right? Okay, so we'll leave you.
Much better.
And we have.
Yeah, okay.
Yeah.
Yeah.
Yeah, you're.
Well, I better draft something then.
Well, that used to be a part. They're more civilized now, but I used to be very much a part of the proceedings. You would stay up all night. Now with post-hearing briefs and that.
Yeah, should have done that.
Yeah, like did a lot of that.
Mhm.
Clean up our talk. Just freaking giving her.
A live, we were in the middle of a live case, sort of like debating it.
I just added that Canadian expression. We're just freaking giving her all the way.
Hey,
Hey,
a boot.
You're both Canadian. No,
Yeah.
you're Canadian.
what do you think? Maybe?
I'm not gonna shake your hand because I know you're sick, but
We, I was talking to some UK folks yesterday and they're like, how foreign experts proceed in the UK. Yeah, I don't know, not as well as, they like it if you can talk the talk. You went to Eton? Yeah, I went to Eton. What year?
Yeah,
It's not kind of litigation.
I think
Like,
so.
but the hierarchy
I'm sure I'm not
goes,
going
Canadians
to-
are generally seen as like harmless.
Yes.
Yeah.
Exactly.
I can actually say I'm from
That's
London
actually why.
City,
Oh, the other one.
London, Ontario,
Yeah.
but
Yeah.
So
I
used to
think
live
it
in
is,
Montreal,
it's like a
lived in
networking
Nova
thing.
Scotia.
I'm going for that. I'm not going for
And
this.
my
Yeah, a
family's
lot of,
from like Nova
like,
Scotia.
technical-
Anyway.
I have some colleagues here.
I wish there
do
was,
they ever, do the Quebec ever bounce over to Toronto? Or,
it's like a totally different system.
I know, I mean, they've got their own world up there.
Ottawa has a joint program. So does, I think, a couple other Quebec ones too. But Ottawa's pretty much done.
Ottawa's like half and half, like Ottawa, Gatineau, or like right off.
K-I
I know, I
M
used to live in
I.
Ottawa.
I wish there was,
Well, yeah, many
where do you
people
live?
live
Knightsbridge. Oh, where across from what? Harrod's Coffee Shop.
Oh, there might actually be. What's that old
There
bridge?
should be.
There's that old bridge, there's an old bridge right downtown. It's like
Well, but the panel is
an example of a certain architecture from a long time ago. And they just refurbished it.
That's
It's pretty.
Ontario.
If you.
Sure, there's everything.
I'll probably give
I
you.
mean, I grew up in a city. Downtown because my kid and I play Pokemon and we usually start at the big park and yeah, there's scary folks downtown. Maybe I shouldn't be taking an 8-year-old to the. Real life?
Yes.
Okay. Welcome back. I hope everybody had a good sleep, especially the associates. So this morning, we are going to hear a closing mini statement from claimant's legal team. So ready to proceed?
1 second. Good morning, Mr. President. The hearing demonstrated that respondent's case on damages is built on a house of cards. Regarding the first head of claim, Mr. Brown recognized that his analysis of the value of assets purchased and expenses incurred by Laird Kaylia to determine the compensation value of claimant's investment is not comprehensive, and there may have been other expenses funded through claimant's investment that he was not able to identify due to the absence of the underlying books and documents. This absence of documentation, however, is completely attributed to respondents, as was evidenced during the hearing, considering that one of the joint liquidators that refused to grant claimant access to these documents is a member of the Kaylian Department of Finance. So respondent cannot now use this lack of documentation as an excuse to undermine claimant's case on damages.
Just to be clear, are you asking for a finding of estoppel, or would you rather ask for a finding of adverse inference with respect to these facts?
Our claimant's case is that the analysis that provided by Mr. Smith with the evidence that was indeed produced is sufficient to demonstrate our case on damages, but in any case, adverse inferences would be appropriate. So additionally, Mr. Smith's calculation analysis of the compensation value of claimant's investments is well proven. Mr. Brown acknowledged that the partially qualified audit opinion in Laird Kayylia's 2005 financial statement does not affect the paid-up capital contributed by claimant. And Mr. Brown could also not deny that the short-term loans given to Laird Kayylia are indeed recorded in claimant's financial statement, which contain an unqualified audit opinion. This shows that the amounts that are recorded in the 2005 financial statements of Laird Kayylia are indeed correct. As a result, claimant's 1.2 million Kaylian dollars claim for the value of claimant's lost investment must be upheld.
Thank you and good morning. The second head of claim relates to the lost profits relating to the Caton City project itself. And Mr. Smith has offered a base case for that claim of 1.56 million and a low case of 768,000. And he based the but-for scenario on the feasibility study prepared by Mr. Peters in the year 2000 prior to the introduction of Circular 10, which forms the basis of this dispute. And as Mr. Brown acknowledged, this study contains projections of revenues, costs, and profits in the but-for scenario. That is, but for the introduction of Circular 10. Mr. Brown also acknowledged that there is no indication that the 2000 feasibility study was prepared for the purposes of arbitration or in anticipation of a dispute. Now, the feasibility study was based on data from Mr. Peters' UK and Western Europe learning centers, which were very successful and achieved a gross profit margin of around 80% on average. And as Mr. Brown acknowledged, the evidence before the tribunal regarding the country conditions in Kaylia provide a reasonable basis to believe that the conditions of demand and market competition in particular were in fact more favorable in Kaylia than in the UK and Western Europe. Respondent has argued that claimants have not provided explanations for why the gross profit margin would be affected by Circular 10, but as was demonstrated yesterday, that's not true. Claimant has explained that Circular 10 resulted in higher operating costs and lower prices per lesson, and Mr. Brown has not contested any of that evidence directly. So in summary, the 2000 feasibility study provides a reliable and perhaps even conservative basis for the projected but-for scenario, and claimants have provided ample evidence of the directly harmful effects of Circular 10 that resulted in the failure of the Caton City project to deliver profit. And just briefly, with respect to the third head of claim, the network project claim, he demonstrated likely success of the Caton City project in the but-for scenario provides an equally strong basis for the likely success of the network project that Mr. Peters had planned. And for the same reasons, that project was foiled by the introduction of Circular 10. Thank you.
Counsel.
Good afternoon, Mr. Arbitrator. The Republic of Kaylia would respectfully like to reiterate its position that the claims presented by LearnFast are fundamentally speculative and lack merit. Through the evidence and the testimony we heard today in cross-examination in these proceedings, the Republic of Kaylia has demonstrated that the claimant's alleged losses are overstated, unsupported by credible evidence, and rooted in unrealistic assumptions about the feasibility and profitability of the Caton City project and the so-called network project. The experts today have shown that their numbers and valuations, claimant's expert today has shown that their numbers and valuations are completely speculative and not grounded in any reality that purports to consider the fact that Kaylia is a developing nation, not another Western nation or the UK. With respect to the claimant's evidence, the financial and operational data that is relied upon by the claimant's expert, Mr. Smith, is incomplete, speculative, and in some cases unverifiable. Mr. Smith told us today that he relied on unqualified financial statements and self-reported data from Mr. Peters, which undermines the credibility of his valuation. Mr. Smith also stated that he attempted to reconcile this gap using financial statements of LearnFast UK, a separate, completely different entity operating in a completely different country, a country that has vastly different and incomparable economies than that of Kaylia at the time. Mr. Smith has already highlighted the discrepancies in the claimant's investment and profitability assumptions, not taking into consideration the risk factors associated with investing in a developing nation such as Kaylia, further demonstrating the absence of a robust evidentiary foundation for the damages claim. Mr. Smith in his testimony provided that Kaylia's market is a new one with uncertainties, and that Mr. Peters had not previously invested in Kaylia, as his experience was limited to Western Europe and the UK. He also admitted that there was no comparable enterprise for benchmarks used in his valuation of the investment in Kaylia. The evidence today showed that the claimant's invested capital is significantly lower than alleged, and the quantum claimed is unsupported by the evidence. There's also no evidence that the investments were actually spent. Claimant's expert used a 10% discounted rate, which he calculates based on US-based NYU professor DeModern's 9% weighted average cost of capital. At best, claimant's expert relies upon another Western economy that does not take into account the volatility of the Kaylyan economy. And at worst, claimant's expert surmises, based off of no empirical studies or research, as he indicated, that the Kaylyan economy would remain unchanged in 6 years and perform identical to its Western counterparts, based off of an overly simplistic and overly optimistic model, which are key deficiencies to his analysis. The original margin estimates were never adjusted after the original feasibility study, and the discount rate used by Mr. Smith, again, overly simplistic, whereas Mr. Brown's analysis showed that he used the capital asset pricing model, which again takes into consideration the commensurate risk involved. And if we account for both of these, there would be 0 damages. Both the Katon City project and the network project were unlikely to be profitable under any scenario. Kaylia's valuation of lost profits remains nil, reflecting the speculative and overstated nature of claimants' claims. The bottom line is, Circular 10 did not cause the alleged losses. While the claimants argue that Circular 10 rendered the Katon City project and the networks project unviable, the evidence showed otherwise. Even before Circular 10, the Katon City project faced delays, operational challenges, and lower than expected profitability due to misaligned market conditions and flawed business assumptions. They overestimated demand for an international learning center in Kaylia and underestimated the cost of adapting its model to local conditions. Kaylia is a developing nation, again, that faces increased uncertainties around its investments. There were no concrete steps taken, no feasibility studies, no licenses, no contracts that were taken into consideration in assessing the viability of a network expansion. It was simply irresponsible and a mistake on claimant's part to not conduct proper due diligence in a riskier and more volatile economy. The claimant, Mr. Peters, as an experienced international investor, should have anticipated the potential for regulatory changes in a developing country like Kaylia. His own failure to conduct adequate due diligence or establish contingency plans further undermines its claims. Regulatory risks are inherent in cross-border investments and cannot form the sole basis for their damages claims, again, without credible evidence or disproportionate harm. The claimant's assertion that Circular 10 and other measures prevented the development of the network project is also unsubstantiated. As mentioned, Mr. Smith's testimony revealed that there were no formal agreements, investment licenses, feasibility studies, or regulatory approvals for the additional locations. These were aspirational ideas, not actionable projects. The Katon City project, which was operating at a loss throughout its operations, was intended to serve as a foundation for the network project. However, a loss-making project is an inadequate basis for expansion. The claimant's expert also admitted to relying on a speculative mitigation factor of 20%, 50%.
Sorry, the tribunal secretary says she's giving you an extra 2 minutes, but you have to
Oh,
wrap up.
apologies, I'm just wrapping up.
Okay.
This reliance upon a mitigation factor highlights the uncertain and conjectural and arbitrary nature of these projections. Mr. Arbitrator, the claimants have failed today to meet their burden of proof. It has not demonstrated that Republic of Kaylia has acted unlawfully or that the alleged losses are directly attributable to Circular 10 or other measures taken by the Kaylian government. Instead, their losses arise from unrealistic projections, speculative expansion plans, and an inability to adapt to market and regulatory conditions, all due to claimants' own doing and lack of due diligence. We respectfully request that the tribunal dismiss claimants' claims in their entirety and award costs to the Republic of Kaylia. Thank you for your time.
You're welcome. Okay, so now I get to tell you what I was thinking. Luckily for you, won't be everything. I'm going to tell you what I was thinking. Too many thoughts in this brain. So obviously, both parties did a great job, especially given, it's hard to do this in such a short compressed period. But we really got the sense of, I think, many elements of what's involved in the cross-examination and the redirect. It certainly is a credit to the two witnesses that they were able to demonstrate such knowledge of their field and of this particular case to be able to really help you with that. So let's see. This is just going to be a running. I didn't organize it. So this is from the beginning to the end. Be careful about pronouns. Sam Smith said a number of times, we were denied access, implying that the expert might be a little confused about their independence. Kind of thing. It's the kind of thing that an arbitrator will pick up, but not tell you about. They'll just note it. Always ensure that the arbitrators are on the same page when referring to documents. They're usually quite old, and so you want to make sure. That's why I kept asking everybody about pages for that reason. You were all good to make sure that the witness was on the right page, but take a look at the arbitrators. Although, to be clear, some arbitrators, like me, I don't follow along. I'm listening, but I'm usually doing something else. So you've got to figure out which arbitrator is doing that, not wait for them, because you'll be waiting all day. So Sam's repeated references to documents having been withheld without challenge by respondent could reinforce the proposition for the purposes of drawing an adverse inference. So he said that a few times and wasn't caught on it. And there was this bizarre sort of hearsay moment where Peter's knowledge and experience had been commented upon by the damages expert as if he were speaking for him. I'm surprised that the claimant's counsel didn't interrupt. I would have if there had been a third question. There'd only been two, but at the third, I would have said something. Questions about the economy generally, it seemed to me that belongs to the field of an economist. We didn't obviously have room for economists, but if I were the valuation expert, I would probably want to, denote the borders there and not go too far into speculation. I was much more aggressive all the way through than I would normally be, kept interrupting. I normally not do that, but there's just no time set aside for tribunal questions at the end. When, by the way, tribunals do ask questions, it's always important to remember as the arbitrator that whatever question's been asked, you have to make sure both parties don't have follow-ups, because it's so easy to just go bump, 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 and then you forget to do that. And then that's a due process issue. Half of what I asked, I wouldn't have asked anyway, but I would have thought it. Just better to wait and see, usually though, if counsel's going to get to the same point rather than jumping each time. Let's see. Oh, there was some talking over of the expert. Obviously, the transcription is a problem when people start talking over each other. Also, I think one of you, I don't remember which, didn't identify yourself when you said hello to the witness for the first time. It's always a good, cordial thing to do. It also kind of sets the stage. There was an open-ended question about whether Sam had any evidence to support projected success of the network. Very dangerous, especially because he was a really good witness. And when they have a good witness, don't give them open-ended questions that they can knock out of the park, which he did. Some of you needed to slow down a bit. And in this regard, it's important to get used to stale air, because this isn't radio. It's okay to have stale air. In fact, I remember before actually, I guess it was when it was my first university degree in the 90s, maybe 80s. Anyway, 80s, yeah. I sold stereos and electronics. And the one thing I learned from that I've never forgotten is to close something, to close someone, whether it be on buying something or on any other point, to close them, use the quiet to your advantage. Make them uncomfortable. You have to feel very comfortable with air. And so that would be one thing. Again, though, I'm not suggesting you all did or didn't do that, because it's sort of hard in 15 minutes, but just that thought crossed my mind. I was still a little uncomfortable with the whole idea of where we ended up with the role of auditor versus the role of valuation expert, and whether the auditor, in what circumstances the auditor's evidence should be relied upon versus looked behind, essentially. I think this is one you could write a paper about. Someone said must be upheld. I think might have been you. tribunals don't like that. It's like, no, I'll decide what's, don't tell me what. But it's good for emphasis, but that's what happens. Adverse inferences, that actually would be quite interesting. No time to do it here, but I'm not sure. I can't think of the case where adverse inferences actually got into the damages analysis. Probably that's because normally if you can develop the evidence, you don't need, if you already have the evidence, you don't need the inference. But it'd be interesting to see if that's happened. You all reminded me of S.D. Myers, because that was one of the very first cases I worked on, S.D. Myers versus Canada, and it's where we had a population of bids and quotations that they had sent out to their potential Canadian customers, but they got shut down before they could do it. And we used that population of bids and quotations against their US success with bids and quotations, and we're able to actually get damages based on that. So happy memory. Danger in suggesting that the same evidence supporting the better grounded claim also supports the speculative network claim. I think that might have been you, because that's like, oh, so if I don't find that, then, let's see, went too far by saying claimant or the expert, oh, this would be you. Claimant expert did nothing, rien, to account for the differences between regulatory environments. Even reality was mentioned. So I found that a little bombastic, including alleging that it was simplistic. I mean, because that almost denigrates the character of the witness and therefore sets people off. You also said some cases unreliable. Okay, which? I know it's a closing, but still, which? Like, you have to give me a hint. Also, there was a misrepresentation as regards what Mr. Smith said, read a 10% discount rate. He explained in the answer to the question that he started with 8 and added 2, not because of what the professor had said, but because that's where he reached. You attributed to him that he did rely on the professor, which was your questioning, but he answered your question, so you shouldn't put it in the close, because, I saw that. Escape causation. Final point is, and this is a little teeny thing. I noticed in your speech sometimes in this close, probably because you wanted to get away from here, that there was a drop off in your the last syllable of the sentence. And when you drop off the last syllable of the sentence, whether it should or shouldn't mean anything, to me, it means you either don't believe it or you don't want to make it. And so that's because it's trailing off. So those are all of the thoughts I had. Does anyone have any questions about those thoughts? Like, that's good. I hate to be questions on my thoughts.
Thank you.
Great. And so I think now next we have teams to move back to plenary room, which I think has happened because there's more people here than there were before. Are there any teams still?
I think there's teams to come. I wonder if we can hear from the councils themselves just to reflect on.
Sure, that'd be great.
Themselves and maybe even the experts who were there so they can get
I definitely like to hear the experts.
Get their views as well.
Yeah. So how was this fun? And if so, how?
It was really interesting, and it was helpful because I think as lawyers and as somebody who's like afraid of math and numbers, we're like kind of faced with having to deal with it and having to like get into understanding it. And so having the discussions with our expert and talking through everything helped make a lot more sense. And so I think it was a very useful exercise for us.
Yeah, I completely agree. Both
scared of numbers too.
Yeah. Both on the substance of it, because I think a lot of lawyers don't get enough, at least from my perspective, don't get enough exposure on the damages side of things, and don't get to engage. At least I haven't with it, but also on the exercise itself, because you can watch it as many times as you want, but there's nothing like being in the chair to be able to actually know how it feels. So this is really helpful. Thank you to everyone.
It's funny. I remember in 1984 and 85, I was part of the team that won the provincial accounting championships each year. My dad was an accountant and then a lawyer. Although it wasn't until I had my 8-year-old who is gifted in math that I ended up reacquainting myself with both math and accounting, because the little fella, I have to keep ahead of him. So I've got really good times tables again, because he does that. How about our witnesses? Any thoughts?
I really liked your comment before about leaving some dead air and getting comfortable with that, because it is, as an expert, you're trained to say very succinctly 6-word answers. And if I think you might have done it a couple times, you just get a look like carry on. And that's really dangerous as an expert, because you're thinking, okay, like maybe I'll try to expand on my reasoning or provide some, and is that ever, you have to, as an expert sitting there with all eyes on you, just say, I'm not going to speak either. Like
Yeah, because you want to help.
100%.
The general notion of that anybody who's a witness who is a professional is, I want to help.
Yeah, well, it's sort of, there's a look of expectation and dissatisfaction on counsel's face. Like you're going to have to expand on that to fill your role, which isn't true, but it leaves you with the impression. And stylistically, both counsels did a really good job of summarizing what you've just said back to them in a way that is helpful to their case. And that is so effective, because I think the tribunal hears it and says, is that what this witness really just said? Leaving out the weak parts and focusing on a very succinct, helpful comment. And sometimes the witness, you have to concede. Yeah, in essence, that's what I've said.
Is he coming through on the speaker? Yeah, okay, but just want to make sure. We wouldn't want to lose these bon.
Yeah.
Okay.
I'll just add briefly, it was very fun. Thank you all. I can't speak for all experts, but they often love to talk. If you give them an inch, they might take more than the inch. That said, I think what's fun for us working with, attorneys is the chance to educate, talk about some of those more difficult concepts. And it's a good litmus test. If you can't understand enough to explain it to your mother or whoever, that might be a good test for whether you're ready to explain it at its fundamental basis to the tribunal and make your point. So I think the preparation and then seeing those messages, seeing the understanding come through the questioning, I think using the experts as part of that process is really fun for us, at least. Hopefully you guys find the same, but we appreciate being able to participate here.
Anybody from the other exercises have anything to add? Probably want to get a mic if you're that far back.
No, I will shout.
Okay.
Very easy to correct. So I was just gonna reiterate that both teams, they did a marvelous job. This is something that I'm also trying to, it's a skill set that I think some of us trying to hone the skill set. I love the fact that both teams managed to narrow down and highlight the discrepancies. They didn't necessarily do all on stuff that they, they just disqualify experts for the sake of disqualifying it. They understood what was the metrics and what was the overlooked risks or information that they were presented the expert, and they did not deliver it, and it kind of impacted the final analysis or final status. So that was a very great job coming down with this sort of putting down these sort of great questions and creating this picture that what we're missing and why those analyses were not reliable. So it's not an easy. I know it came across as being very easy, but I think it took a lot of probably courage, but at the same time critical thinking, which I really appreciate it.
I'm also in favor of critical thinking.
Can I ask a question to you?
Yeah.
The point about closing statements, maybe coming up to and perhaps going a little bit beyond the edge of what was actually conceded. I see that a fair amount. And you probably do as well. How does the tribunal deal with that?
They don't like it.
Yeah.
They don't like it because their job, the counsel's job is to assist the tribunal in coming to the correct conclusion. If they're going to be misrepresenting what the evidence is and what the law is, that's problematic, especially in a closing statement. And also, as a general rule, international arbitration not being domestic litigation, and especially not American domestic litigation, basically, maybe it's the civil aspect of it, the civil law input. We don't like bombast. So Canadians are fine with that, well, English Canadians are fine with that because we're generally not, we actually always refer to the other counsel as my friend. So I was actually shocked when I realized not even everybody does that. but other cultures, but no, but we like that. My friend, we like the idea that we're all here to help come to the right conclusion. Yeah, I know perhaps it's to a certain degree of fiction, but if it's what's the word? If it's the Whiggish fiction or the Whiggish reality that the tribunal has, then you're going to have to live with it. And I think that it is most tribunals, most arbitrators do believe that they're there to come to the right conclusion and want assistance with that. And they take it in good faith. Everyone's going for that angle. But if somebody starts going beyond, making representations that clearly weren't accurate, even if it's simply a matter of them, so whether that's them saying that I come to the conclusion that they know what they're doing and they're doing it, it's not much better to say they don't know the difference, that they said that anyway. Like, either way, it means that they're either slapdash or they're not acting in complete good faith. So, although to be fair, it may just be that I get upset, I get grumbly. It doesn't mean because I still want to come to the right conclusion. So whether or not I like counsel ultimately doesn't matter. I just want them to help me.
Nothing on what you stated, because I've rarely seen arbitrators being so proactive as you were. I think it's a good diplomatic way to put it in. Some arbitrators might intervene, some won't.
Yeah, some do, some don't. I normally wouldn't, like I said before, I would not have intervened nearly as much. I would have waited to see if someone come up with the thing I was thinking. I just write it
Some
down.
of your questions were very helpful, actually. It was very important. So I was wondering why most arbitrators kind of shy away from making that necessary intervention.
I think it's cultural. In my case, I have ADHD, which probably a lot of people know just because I was the co-chair of an ICC task force on disability inclusion. So as someone with ADHD, I know that I have a lot of ideas that come right away and I want to get to them. Just like we always get caught for going through red lights because we want to be first. So because I have this particular condition, I am very careful to write everything down. And even if it goes against my ADHD nature, I want to hear what everybody else says, because it may well be that they cover it. And if the parties cover it, that's a lot better than my having to get it out. I would like to think, though, that the times I would intervene were just the ones you talked about, that they were all necessary and helpful and moved it along. Although in this particular exercise, I was also cognizant of the fact that there's folks watching and they may have differing understanding of or background in damages issues. And so I wanted to make sure that I kind of helped show the framework of it, which is why I mentioned the thing about the different professionals having different roles and responsibilities, where they're concentric and where they're not, because that's a useful thing for us to know. That's my professor coming out in doing that. But that was sort of the goal there.
Not to harp on this, but I feel like because some of your question was so good, especially the question about the auditors and the other stuff, that's like, why you answer this question? Have you been on the other side? I was wondering if some arbitrators might be reluctant because that would put a bit of a bias on them.
No, it doesn't. I mean, our great leader here, who's not paying attention at the moment. I have a question for you. You have to be part of the game now.
Okay.
When I was asking you questions a few weeks ago at a hearing, did that seem reminiscent, or did I seem to be doing? I seem to be. I like to deal with principles. I like to ask about principles and logic.
You're not asking me for feedback.
How'd you like to feel? How'd you like to feel? Like, did it not feedback necessarily, just but
No, it was consistent. I mean, how you were behaving here was consistent there. You're clarifying points. You're really wanting to understand. I got the impression you were wanting to understand.
Yeah.
You wanted to really get to the bottom of it. Now, whether it goes there or not.
Exactly. Yeah. Yeah.
It's irrelevant, but you're just trying to clarify. I mean, you've got the witness in front of you right there.
Yeah.
And now's your moment to clarify.
Yeah. And I think that's.
And same for the other witness. You're looking to understand.
Yeah.
Clarify. Get your notes clear, and then you have the information available.
Because it always goes back to the fact that I want to come to the right conclusion. And so why not ask to make sure I get it? Part of that also is just, it's realizing that it's okay if you look like an idiot. Because a lot of people don't want to ask a question if they think that they should know the answer, because they don't want to look like an idiot. But I say, feel free to look like an idiot, because the bottom line is you want to have the right information. So maybe you are slow and you don't get it. No problem. Ask the question as the arbitrator. And I don't think that one should feel, like someone's watching you and thinking, oh, he should have known that. Who gives a rat's ass whether they should have or not? The fact is, my job is to come to the right conclusion. So that's why I do that. And I do generally have a first principles kind of approach to things. So that's why I always like to know where it all fits. So are we done?
I think as an expert, you also appreciate that you're asking the questions.
Yeah.
Yeah.
Because I think the worst thing is that, you know, you don't know if the tribunal got it or not got it. I don't know, but at least you get, well, because I think that's what we're there for, to be helpful. And I think therefore I certainly appreciate it. So
Yeah, I also find it, otherwise, if tribunal is not paying attention sometimes, it's also not, I mean, I like engaged tribunals. Asking questions and prodding is not a bad thing.
Although again, putting on my disability inclusion hat, I would just note, you might not think they're paying attention, but if like they're neurodivergent like I am, I might just not be looking at you, but I'm listening to everybody. It's more likely I'm listening to you if I'm not looking at you.
Yeah, no, I agree.
Yeah.
No, I'm talking about a particular, I'm from India. So we have a lot of old retired judges who, in domestic arbitration, they're not listening.
Funny story, very brief story. Fali Nariman was the tribunal chair for one of my cases. It looked like he was sleeping.
He's a sharp, he's a different.
This is the funny thing though. He looked like he was sound asleep. And then all of a sudden, out of the blue, he'd ask a question and he was right on. He knew exactly what was going on. He just had his eyes closed.
He's a very sharp, you know, he's.
Yeah, it was fascinating. It was just like, because you'd think he was asleep. You're thinking, uh-oh, we got a due process issue. We got to figure this. Nope. He heard every word. He just was resting his eyes, as my dad used to like to say.
But to accentuate that point, I think it's really helpful when counsel sort of does little points in the map. Like, you know, we're closing out the so what about the UK versus Kaylia financial statements, especially on accounting evidence, which is very sort of arcane, to end that with, so this is what we've learned.
Yeah.
From that, because that helps you understand the relevance of the 20 questions that just came before, which if you're not an accountant can be like, why do I care about accounting standards and underlying records?
It also makes it easier to rest on that point in your argument.
I totally agree. Yeah.
So there's that too.
The inferences you can draw from that line of questioning.
Whereas if you left it open and didn't ask that sum up conclusion, it might not work. Because the tribunal, for the most part, I think notices when you didn't ask that final conclusion and yet nonetheless make a reliance on that.
It could be a lack of courage, right? Because you could paint someone into a corner, like with the 20 questions I've just asked you, you have no choice but to say yes to this. But when I ask you that fundamental fatal question, you see them squirm and they'll do anything but to give you a straight answer on it. You've got to get it.
Yeah. Although to be fair, I find usually if there's a rule of three, when you're counsel, 3 times, even 4 times you go at it and they're just not going to help you, you've demonstrated it anyway. And so you just don't wait for someone else to tell you to stop and move on. Usually I think 3 times is enough. If they're not going to give it, they're not going to, and everyone can see that. So
there was a couple times, not to knock on Jared, but when they came after him, you know, he gave really good evasive answers 3 times and there's nothing more you could do. And I think the point was made, sure.
Although, of course, what you do as a counselor, you say, okay, I think we've gone as far as we're going to get on that and then move on. So you're making sure everyone is paying attention. So, and then you move on. I know I keep switching between counsel and arbitrator, but I'm still young.
What is the point about economic analysis being off limit? You don't necessarily.
It's not that's off limits. It's just that when one starts asking questions about the overall performance of an economy, I mean, I'm not a valuation expert, but with my limited accounting knowledge making me dangerous, it seems to me that you need an economist to talk to certain elements of the way the market is going to. Whenever you use the word the market, it's usually trying to get an economist.
To a degree, I think if I've got a research from an investment bank, a well-known one that says 10% growth.
Yeah, well, then you're relying on their.
You're relying on their, and it's, I think, up to, in that case, the respondent to refute and say, well, you know, that investment bank has investments in that country and an interest and it's unreliable.
Yeah.
I don't think there's anything fundamentally wrong with saying there's research out there which I've relied upon.
No, it's when there's an absence of research that one, you know, basically starts talking about pontificating about the economy. And it's like, well, that's great, but you're a evaluator. I understand that means you have to know markets and how they work, but that's why we have economists, evaluators, auditors, you know, we have these different professions for a reason. They all overlap. They're all concentric circles. But you want to make sure, I think, as an expert, that you don't appear that you're going beyond your remit. And that's both in the sense of becoming an advocate rather than being an independent expert, but also in the sense of speaking to what it's been proved you know, like, you know, that that's your expertise.
But if it's not hotly contested, you would need Viva.
Yeah, I mean, nobody's gonna, I mean, I'm being nitpicky here just because it's a limited thing, but yeah, I mean. Look, should we start over because more people came in? This is being recorded though, I think, isn't it?
Yes.
That's too bad because like with my conference, we transcribe everything. And I like to always make the joke throughout that I'm gonna change that. Like whatever it is, whatever joke I made, I can take it out. But it's kind of hard to do that with a video. But I just add in some coughing. Should I do some coughing now to bring it in?
If you wish.
So I think we're done.
I
then.
mean, maybe what we'll do is also just get some, because I think in
Yeah, we're not done yet.
because we have people online and they've been listening to the feedback, and I think that's been, Todd, you've been very very enlightful actually. So thank you very much for having to really share your knowledge with everyone, and I think that's been appreciated. I just wonder whether we can get some feedback from the other groups. I see
Some people I didn't hear very well.
Can you hear me?
There's a mic right there. I mean, not you, but the other people you're gonna give it to.
Okay, so hopefully everyone can hear me. So maybe we'll just get feedbacks from the other rooms, just in terms of how it went in your sessions. Appreciating we've had some feedback here, but just from a general perspective. So I don't know, maybe the arbitrators in the other rooms. I don't know who wants to go first. G?
Just do some.
Yeah, sure. You put me on the spot. Yeah. Do I need it?
I don't know. Use it anyway.
I'll use that anyway. So, yeah, well, first of all, I have to say that you have amazing counsel and amazing experts. I was very, very impressed. There's great level, very high level of preparation, very high level of professionalism. Most experts were just at the top, and I think some counsel had a little hard time dealing with the expert, which should be, because as lawyers, we are not experts. And sometimes if you don't control your cross-examination, the expert's going to kill you. They're just going to, or because they will show that they are real experts. You're not an expert. So I think from that standpoint, it's important for counsel to be very succinct and very pointed in their answers, and to not let experts to go away, and sometimes you have to be firm. You have to actually stop. But you also need to be, as counsel, you need to be balanced. You need to keep your eye on the ball and see what are the most important key issues in the case. What are the important points in the case? If you have a case where there are certain damages that are much more significant than the other part of damages, you need to allocate your time appropriately. You need to allocate your time to make sure that you have sufficient time to address all of the heads of damages, all of the key parameters on the damages. I think that's sort of like overall comment. I'll let other people talk.
I'll take, since I'm here, courtroom 3, I guess. And so, no, I think first off, I'd like to say that this program is an excellent idea. I mean, the fact of like setting this up and doing it, having, practitioners and students and everything learn this at a junior level is key, because it really builds on itself. And so well done. And then the use of real experts, people who actually have testified before, gives you a realistic sense of what it's like. And we saw the same thing in my courtroom. We had excellent answers by the experts who were really, they were not being soft. And so when they were given an open question, they were talking and they were using up time. When they were kind of led to something that then was adjacent to something that was not necessarily great for that questioning counsel, they clued in on it. And so people were learning that you've got to be very careful about how you guide an expert, how you control them, and methods to do that, and then how it ties into the format of questioning. So this idea of closed questioning and leading them, and why open questions can be very dangerous. It's not just a matter of, just because, but it's because it allows somebody who's well-trained, knows what they're doing, to really support their opinion and not be pointed out to the weaknesses, because nobody likes to talk about that. So we really encountered that in our group, and I think had a good learning process. And then the redirects as well, learning about how it's important to be listening to the other side as you're doing something. It's very difficult to be preparing for your redirect or trying to like figure things out and listen to the questions and listen to the answers. So those types of multitasking really came about in discussing it. So I think overall, we had a great experience, a lot of learning that was going on, and a lot of discussions both between the experts, the council, and the debrief went really well too. So, but really excellent from my viewpoint overall. So.
I just make a comment about redirect, and as an expert, from my perspective, you don't want to hear a redirect because sometimes you don't actually know where the council is going and where the question is. So just to put it on the record, I know it's being recorded, etc. It's not, I mean, and otherwise be very clear about what the question is, etc. Joe, I know you had a bit of a walkover on yours, but
well, I was going to say the respondent council was so intimidating that claimant council decided not to turn up today. So well done, well done, Veronica. But as a result, we had a curtailed arbitration. But nonetheless, I hope it was useful and helpful. She did a great job in the cross-examination. The experts, well, the one that was actually being cross-examined was a pretty wily expert and used the opportunity to take her on a little bit of a dance around when he had the opportunity. But I think also the respondent's expert provided some very helpful feedback in terms of what the game plan was and how that was conveyed. So all very positive. And I think the probably three key points that came from this, and I'm conscious I missed the beginning of the session and you've already no doubt covered it, but the three key points I would say are timing, timing, and timing. It's all stating the obvious, really. I think even the best laid plans, you can get thrown off your what you want to cover if you don't have control over the witness, and using the tribunal as well to help you control that witness. If they're, depending whether they're interventionist or not, you might not need that. The tribunal might already be there. But sometimes it's perfectly, I think, in order to turn to the tribunal to seek some to help control the witness. But I think another little basic obvious things again, or maybe not so obvious, being really clear what you're referring to, because this gets recorded in your transcript. So it's not just paragraph number, it's the page number, and being really clear on that. But I mean, other than that, she did a great job, and I don't think there's very much more I can add from what I've already heard. But well done, thanks.
Thank you. Hi everyone, Clovis Trevino, I'm a partner at Covington. I thought this exercise was extremely valuable and enjoyable. One element that came through in our conversation is that you each have a style, and you have to think about what works for you. What might work for me, a small female attorney, might not be the best way for other people. So as you learn techniques to cross-examine, just keep an eye on what your own instincts, weaknesses, and strengths are, and develop those, exploit those. A second piece of advice that goes back to your point is that you always have to think about the transcript. When you're cross-examining, this is, you have to build piece by piece, building blocks, and then you get to your admission step by step. But you have to make sure that 3 months later, when the arbitrator is reading the transcript, they can get the point. That doesn't mean that you have to ask that last final risky question. That final question might be the killer. You don't want to go that far, but you want to make sure that you build a step-by-step analysis. And one final point that I would make is that I certainly agree that redirect is extremely dangerous. I did it once, and it was a huge mistake. My expert had no idea what I was after. And then I had to lead my expert in redirect, which is a huge no-no, but I had no choice. So don't do it unless you really have to.
That happens a lot though.
I mean, I had no choice.
Yeah, but it does, the leading. But of course, the further you have to lead, the more everybody's
obviously
what's happening.
Yeah. Well, thank you so much for organizing. This was a pleasure.
No, and thank you very much for the feedback. And maybe I'll just give some closing remarks now, and appreciate, by the way, everyone in terms of the councils, how seriously you took it. And that is hugely impressive in terms of the fact you took the time. I know you have a day job, we understand. You're balancing around other things, but also this is a bit like life. But maybe one question I would ask the council is, how much time did you spend with your expert? Because one of the things that I think, yeah.
Sure, yeah, so we had one Zoom call with our expert and a colleague of his, which was extremely helpful in really educating us on issues that we were unfamiliar with. And we also had an open dialogue back and forth via email, which was helpful as well in kind of filling out some of the fine points.
And you'll do a post brief at a bar somewhere with them?
Maybe might have to wait till 5 o'clock for that.
You don't need to wait till 5 o'clock. It's okay. But I would say this is something that I would hugely encourage that you do. In real life, you would spend time with your experts and really learn. Because, you know, I have to say, I take my hat off to counsel, having to talk about something that really you didn't go into law to talk about accounting stuff and valuation stuff. It's not why you did it, but you're doing it. And that's the situation you're in. So it takes a lot of guts to do it. But then to educate yourself, I think, is important. So I think one of the feedbacks we got from other sessions that we do is to really maximize the time with your expert and really try and learn from them as well. And just all the silly questions that you have, ask them all. Yeah, what's DCF? What's discount rate? Really, what's this country risk premium? Yeah, go ahead. Yeah, and that's what they're there for. And I would say that's something that should be done. So thank you very much to counsels for all your effort and thank you to the experts that we had. I think you really knuckled down and gave counsels a hard time. I expect normally you would give them a hard time anyway, but I think you did a pretty good job here. And thank you for the PwC people. And I know we've had some other experts as well here. So thank you very much for coming in and supporting us today. And last but not least, the arbitrators. I mean, just this is what it's about how you feel about it. So I think your feedback is quite important because at the end of the day, I was always told there's only one important person in that room in a hearing. That's the arbitrators. That's it. In fact, even the presiding arbitrator, and you've got to know, he's got to know where you got to know where he is or she is. Are they on the right page? Are they understanding the questions? And you've got to take them along that journey. And it's the same as experts. You're really talking to the tribunal and to the presiding arbitrator. So it's only one important person there. I know you're trying to knock the expert out, but I think that's something that just should be considered in everything you do. But thank you very much, everyone. Appreciate it. Again, we'll ask for feedback on this event, how it went, and certainly we'll like to sort of see how we can improve on the concept. For those of you online, thank you very much. For those of you here, there's a spot of lunch outside if you fancy it. Otherwise, I know there's other fantastic events to attend this week. So otherwise, thank you all for coming.